Today on The State of Us, the important Supreme Court decisions that aren't getting discussed, the EPA, election law, and remain in Mexico. Welcome to The State of Us. I'm your host, Justin T. Weller, joined of course today by the one and only Mr. Lance L. Jackson, your friendly redneck liberal, and the senior resident historian here at True Chat. Today we're looking at the High Court limiting the EPA on emissions, a ruling that some people have probably heard about, the remain in Mexico allowed to end under the Biden administration, and that the High Court has agreed to hear the election law case that could have broad effects across the nation. Now, you may not have necessarily heard much or anything about these cases, and that's because the Supreme Court's released a lot of blockbusters, and there are certainly things like the overturning of Roe v. Wade that I'm sure have garnered more of your attention. But we are going to talk about these three issues today and try to break down for you why it's important that you be aware of what's going on with these quote-unquote lesser cases. And really, I think it's going to be one of those things where whether or not they're lesser will be up to you to decide. They're just not getting discussed to the same extent. But Lance and I, we have a guest today again, don't we, Lance?
Yes, we do.
So Mr. Richy Richardson's joining us again. For those that don't know, we'll let him give you a little introduction here in a minute. But I think, Lance, I was told he needed an opportunity to redeem himself. So here he is.
Well, he's already gotten his rookie pass, so we'll see how he does today.
Oh, okay. So that's by the wayside. Do we have a word of the day since we're going?
We do have a word of the day.
Gloves off?
Yes, we are.
Okay.
The word of the day is nomology.
Nomology.
Yes. It is the science of law and lawmaking. So we're going to do a little discussion on nomology today. Should the Supreme Court have the right to do all these things that it's doing?
So how do you spell nomology, by the way?
Nomology is 4 syllables, N-O-M-O-L-O-G-Y. It is a noun.
Our listeners know, Lance is this boomer and I'm this millennial, and Lance loves these labels. Richie's a member of Gen Z, but why the heck's he on this episode about the Supreme Court? Who cares what you have to say?
Well, I personally consider myself to be a Supreme Court scholar.
Oh,
I know a lot of stuff about the Supreme
19.
Court.
You can be a scholar at 19 now.
That's right.
Okay. That's interesting.
I took the online test. I got my certification.
Oh, there we go. Handing out prizes just
Registered
because
in
you
the
went to the
state of
bathroom
Kentucky.
every day. All right.
Participation awards?
Yes. No. We get a full certificate now.
I participated in the online webinar that was required.
So what are you studying in school, Richie?
I'm a finance, economics, political science student at the University of Cincinnati.
And there's a possibility that you might want to be a lawyer someday. Is that right?
That is correct.
Okay. So I think one of his passions is the Supreme Court. So we've got a lot to cover today. We'll get right into it. We're going to talk about the EPA first, election law second, and remain in Mexico third. So without further ado, we'll dive in to the nomology today and see what we can come away with, and if Richie's able to offer any insight that Lance and I are not able to. So, according to the Wall Street Journal, in a blockbuster 6-3 decision penned by Chief Justice John Roberts, the court said on Thursday that the Environmental Protection Agency, the EPA, had overstepped when it devised the Obama-era regulatory program, the Clean Power Plan. The court said that when federal agencies issue regulations with sweeping economic and political consequences, in this case, rules to address climate change, the regulations are presumptively invalid unless Congress has specifically authorized the action. According to the Chief Justice who authored the opinion, quote, "A decision of such magnitude and consequence rests with Congress itself or an agency acting pursuant to a clear delegation from that representative body." That was, again, Chief Justice John Roberts, who was faulting the EPA for finding new powers in the, quote, vague language of a long extant but rarely used statute. The Clean Power Plan had been challenged by West Virginia and others. Mr. Biden, a Democrat, our current president, called the court's ruling a devastating decision that aims to take our country backwards. So the notion here Lance, right, is basically if you're going to do things that are broad sweeping, or I guess as they put it, have broad economic and political consequences, then Congress itself needs to authorize that. Does that sound like a good idea, bad idea? What do you think?
Oh, it's a horrible idea because it's talking about interpreting the Constitution. It doesn't say anywhere in the Constitution that you have to make a law for this and have to make a law for this and make a law for this and make a law for this. Thousands and thousands of laws and rules and regulations. Okay, so where do you draw the line? And when you're talking about, major items like this that, global warming and there's no political agenda here. And I think that's the biggest far-fetched ideas when we try to argue that the court is not a political entity. It is by far and away probably the strongest and most political entity of all, because they are reading a document that was written more than 200 years ago and then putting their personal feelings and ideas into the decisions that they're making.
You're okay with federal agencies having fairly broad latitude to act without Congress if Congress has delegated that power to them.
Well, you just said Congress delegated the power. If Congress delegated the power, then yes, they have that. Then use the power that you were given. You have been given this such power, said power. So why not then allow them to use the power rather than saying, well, now let's go back and let's write 3 new laws, because when we gave you the power to do this, we didn't mean for you to do this, this, and this. Then why'd you give me the power in the first place?
When you look at these acts, they're written intentionally vague in order to give the EPA and other administrative agencies wide sweeping ability to regulate. And the point is that they can be able to respond quickly to major issues that Congress wouldn't be able to respond quickly to.
I don't disagree with, possibly the reason they were written vaguely. I guess the question in this case would be, is the Clean Power Plan really something that you would contend you have to react to so quickly that Congress doesn't have time to consider it in the first place? And while, yes, I agree that climate change is a pressing, urgent issue and all these things, I think it'd be far-fetched to say that Congress doesn't have time to, consider something of such magnitude. If climate change truly is the catastrophe that we've talked about it probably being on this show, then certainly Congress should make the time to oversee that and make a decision on it.
You're from the state of West Virginia, and the conservative answer to getting more power is, well, let's just burn more coal, which we know is very dangerous to the environment. But I've read article after article this spring and summer with the gas prices. Well, let's just go back to using coal. We know that President Trump ran and said, we're going to use more coal. And so now we get a conservative court and, we're going to change the regulations so it's easier to use coal. And then you're going to argue, well, this wasn't a political decision. Why? Really? Are the American people supposed to be stupid?
Well, one thing we'll talk about today is whether or not it is just political, because the last thing that we're discussing is the court allowing in a 5-4 decision the Remain in Mexico, a Trump-era policy, to be ended by the Biden administration. Now, yes, it was a closer decision. This was a 6-3 decision. But it is that question of, and I guess that's part of what we have to try to answer is, are they truly political, or do they pick what they're political on, and other things they try to be more scholarly? So what do you think, Richy, about future consequences of this decision, future impact?
Well, I think that if you look at the concurring opinion that was written by Justice Gorsuch and was signed on by Clarence Thomas, then you can see that the Supreme Court is really setting itself up to strip all federal agencies the ability to regulate in any capacity. And that's just blatant judicial activism.
So you think that what they're doing would just totally make it impossible for federal agencies to regulate?
I think that that's what those 2 justices want. I think that they're slowly walking towards, it's a slippery slope. And this decision and the OSHA decision that came before it, where they said that OSHA couldn't make vaccine regulations in the workplace, it's just a slippery slope before they say that federal agencies can't make any regulations.
Yeah, I think it's tough because while I agree that I think this is a, political action, obviously specifically designed to curtail attempts to combat climate change, the larger and broader question of something that we all as citizens of the country have to consider is how much latitude do we want to give and how much ambiguity do you want to give to federal agencies with people running them who are not elected and who don't report to you. They report to the legislatures that supposedly report to you or the executive that supposedly reports to you. But how much authority do you want to give? And that's not a right or wrong answer. It's just a question of how comfortable are you? Because as we saw in the Trump administration days, that broad executive authority can also be used to change the policy of such organizations to go the other way and favor, for example, coal. So I think it is people understanding that just when it's not going your way doesn't mean either that then therefore, we want to make sure that federal agencies are never limited. We've talked about, and I think the overturning of Roe is a perfect example of if you want something to be safe, for example, if we really want to take on climate change, the safest and best way to do that is for Congress to act on it. And that way, there is less ambiguity and less question. Same thing with these federal agencies, because while this court interprets it one way, it's possible that a future court could interpret it a different way. Speaking, though, of things that have broad implications, certainly climate change does and what we do on it, regardless of where you come down on it, we've also got to look at a forthcoming case, so one that is yet to be decided, but that the court has finally agreed to hear. And this is an election law case that could have major implications across the United States, and we've got to talk about it. Keep it here on The State of Us, and we'll be right back. The Supreme Court is going to hear the election law case, according to the Wall Street Journal. The court, in a brief written order, said it would hear an appeal next term from Republican state lawmakers in North Carolina who are seeking to reinstate a voting map drawn by the GOP-controlled state legislature that was expected to give Republicans 10 safe seats out of 14 total seats. The North Carolina Supreme Court struck down the map, ruling it violated provisions in the state constitution guaranteeing free elections and equal protection. The state's Republicans argue that North Carolina's judiciary is improperly interfering with their authority, assigned under the U.S. Constitution to determine, quote, the times, places, and manner, end quote, of congressional elections. Critics say the GOP argument would embolden state legislatures to disregard voting rights protections outlined in state constitutions. They say the theory would give state lawmakers more power over not only redistricting, but also other voting issues such as voter identification requirements and voting by mail. The Supreme Court likely will hear oral arguments on the case near the end of the year, with a decision expected by June of 2023. So how do you make sense of any of that? Well, the way that I make sense of it is basically what the argument here is that the U.S. Constitution, right, lays out that the state legislatures will determine the times, places, and manner of congressional elections. And what North Carolina is arguing is that, therefore, it doesn't matter what our state constitution says about how we're to do elections, because the U.S. Constitution supersedes whatever ours says. And so therefore, you can't tell us how to do it in our state constitution. Obviously, this would have huge impacts across the country for any state that has provisions like this. For example, in the state of Ohio, voters by a citizen initiative amended our constitution in our state to require a nonpartisan committee draw them to create, some semblance of fair representation throughout the state. And we've been going through our own legal battles here over those congressional maps, a lot of back and forth. And essentially, depending on how the court ruled on this, obviously, if they came down on the side of North Carolina, it would essentially invalidate all that and say the state legislature doesn't have to do what the state constitution says because they follow the authority of the U.S. Constitution. So a very interesting attempt at a legal argument here, one that would certainly have broad implications. No? What do you think, Richie?
Well, I think that if the court takes this to the strictest idea that only state legislatures can control the elections, then what does that say about the Voting Rights Act? And what does that say about other federal legislation that regulates how and when, the time, places, and manner that people can vote? And what's to stop states from ignoring the Voting Rights Act as well as these state constitutions?
It's a fair point. Maybe we have a issue with what the Constitution says about who gets to determine those things.
Or maybe we have an issue with this interpretation of the Constitution. The founding fathers didn't create state legislatures. The state constitutions created state legislatures. When the Constitution was written, there weren't 50 state legislatures. All of those came either before or after the Constitution and are all designed in some ways different from the other.
The Constitution says the times, places, and manner. That's what it says. Those are the words.
Which means it's open to interpretation. And therein lies the rub. And what we've always looked to the Supreme Court historically to do is to make sure that the majority doesn't take rights away from the minority. Now, to your point of earlier, what we did was we made constitutional amendments to stop the states from doing that. And so what your argument is, well, we need to make all these new rules because otherwise these political parties are going to subjugate the efforts of the Constitution to make things fair so that they can gain power if we don't pass specific laws. I'm not saying you're wrong. I'm saying that's really sad that we talk about freedom and democracy and we take it away because two groups are fighting for X amount of power. And so we will subjugate those rules so that my group gets in power because my group has better ideas than the other group. And the heck with other people and having personal freedoms. We're going to rule and tell you what you have to do. And going back to Roe Wade, right? What right do you have to tell me what I'm going to do, not harming anyone else?
Well, and that's the question of, right, there's the interpretation of what constitutes harm of somebody else.
But that's the whole point of, see, this is when we say, when the court stands on high and says, we're not doing anything other than what it says. No, they're interpreting it and they're bringing in their own personal biases. And this one all happens to be about who can control voting and how it's controlled. And the problem is with this, okay? And Richie's comment about he's the expert because he's got the certificate from Kentucky. The state of Kentucky has the courts have ruled that their school funding is unconstitutional for 30 years. 30 years ago, the state of Kentucky, the courts said state funding is unconstitutional. Kentucky has not changed once its funding of education in 30 years. So you have the other side of this is, what power do the courts really have?
I think when you tamper with things like the elections and who gets to vote, this is the sort of thing where if people decide to disregard, what the Supreme Court says, it is how you begin to fall, regardless of what they say, because we're all sort of acting like they're for sure going to rule on the side of the states, but I'm not sure that anybody, given, what we do know about the court, could say definitively that that's what's going to happen and know that that'll for sure be the case. They may come down on the other side of it and say, especially because if you're looking at this, and I'm not arguing that this is a way that you should interpret the Constitution, but if you care about the people that wrote it and what they were probably intending when they meant it, I think you'd find a lot of people that would say it's probably not likely that the founders who were writing this meant that state legislatures shouldn't have to listen to their state constitution in deciding the times, places, and manner of congressional elections. Now, maybe that's how it's written. Maybe it leaves that sufficiently vague. But if you care about how it was written and some of the people on the court do care about the quote unquote the intent of the writing, you're definitely into an area then that's kind of tricky to determine how they're going to decide this. Because again, I'd like somebody to try to make the argument that the majority of people who were writing the Constitution and voting on it believed that this someday would be interpreted to say, oh yeah, you don't have to listen to your state constitution. Don't worry about that. It doesn't matter. Because they were all very concerned about, the balance of the federal and state governments and how much power states had versus the federal government and the ability of states to craft their constitution and decide what was right for them. And to say that your state legislature basically has this unchecked power where they don't have to listen to the laws or the constitution of their own state, I have a hard time believing that, that when they wrote this, they were thinking, oh yeah, that's what we're going to do. And the reason I'm saying that's relevant is not because that's an argument to not do it, but I'm saying there are people on the Supreme Court who supposedly care about that, who may very well say, I can't, even though it says this or sort of is vague about this, I don't think that's what was intended. So therefore, that's not.
So
what
is
we're
it time
do.
to blow up this great experiment, have 50 individual governments and do away with the United States of America?
Well, that's a
since we don't all want to
show.
We all don't want to live under the same rules.
We tried to do that one time, more than one time.
Well, I think we're close to doing it now. I really do, because I'm driving and there's this bumper sticker on the back of this vehicle that says, shoot your local Democrat. I mean, if that's the way people feel, is it time for us to go to 50 individual states and we'll all just get with our own people and say we only want to live with people who think like us?
Richie, final thoughts before we move on to remain in Mexico?
As Lance was saying, I do not think that the Supreme Court, or at least I hope the Supreme Court would not side with the Republicans hoping for the independent state legislature theory. But, you don't know. And I do think that state constitutions created state legislatures, so they have every right to restrict them in what they can and cannot do. Because without constitutional checks or without some sort of check on the state legislature, then what's to stop them from breaking their own rules?
I think the counter would be that the voters check the state legislature. If they don't like the state legislature, then they can change them, and that's the check. And the U.S. Constitution, which is ordained by the states and their legislatures and by the people who voted their congressional representatives into office, they check that. Of course,
how effectively can the people check the state legislatures when the state legislatures are hyper gerrymandered and twisted to extreme partisanship?
I agree with you. But there's that also question that the Supreme Court has considered before that basically says gerrymandering is not unconstitutional. So maybe we should change the Constitution to reflect that we don't want that.
In
since
that
the broad
decision,
majority of Americans do not support gerrymandering.
In that decision, the Supreme Court never said that gerrymandering was not unconstitutional. They said it wasn't a decision for the courts.
In other words, we are going to leave it up to the states. But this then brings that into question of, well, you can't really leave it up to the states if if you're going to supersede the state's authority to make that decision. So there's a challenge there then of, well, you can, right? But you have, again, left some degree of an unfettered check in place on state legislatures. So let's talk about Remain in Mexico allowed to end, because so far it sounds like, man, this court, they are just Republican through and through, and they hate the Democrats, and there's no way they'd ever do anything that would help the Biden administration. But they did. They did. So let's talk about that. Keep it here on The State of Us, and we'll be right back. The Wall Street Journal tells us that Remain in Mexico is allowed to end. The Supreme Court, in a 5-4 decision, ruled that the Biden administration could cancel the Trump-era Remain in Mexico program, which required authorities to either jail asylum applicants from Central America or deny them U.S. entry until their cases are resolved. The court found that the Biden administration acted within its discretion by ending the program, overturning lower court rulings that required the Department of Homeland Security to enforce the policy, which President Biden campaigned on ending. Writing for the court, Chief Justice John Roberts noted that Congress hasn't provided sufficient funding to detain the vast number of migrants seeking asylum. The lower court, quote, imposed a significant burden upon the executive's ability to conduct diplomatic relations with Mexico, the Chief Justice wrote, joined by Justices Breyer and Kagan and Kavanaugh and Justice Sotomayor. Texas and Missouri, both Republican-led states, sued to stop the administration from ending the policy known formally as the Migrant Protection Protocols. Lower courts, including the Fifth U.S. Court of Appeals in New Orleans, found several reasons to keep it in place. Congress couldn't have intended to hand a federal judge such power over U.S. foreign policy, the court concluded in its majority opinion. So, Lance, the court's political. It's biased. It's, they don't do their job. They're out to get Biden. They just helped him, though, didn't they? They just let a Trump era policy end.
Barely, right? 5-4.
Well,
and so only one. So one of them jumped ship.
Whether it's
if Kavanaugh,
9-0 or 5-4.
If Kavanaugh, no, it makes a difference, right? Because it's not like, all the other votes were like 6-3, right?
If Kavanaugh didn't jump ship, this would have been a 6-3 decision.
Exactly. My point being is the idea on all three is, well, we're not going to give the government, we're not going to give the executive branch a power unless it's stated by Congress. So my question is, why did we vote one way on two of them and a different way on a third one if it's not political? Because they're asking to your own description for the same thing. So if it is just based on my interpretation of the Constitution, I should have voted the same way on all of them. Because they're all three trying to limit the power of the executive branch to do anything that Congress has not directly stipulated the executive branch to do.
I think the distinction, I think they would tell you, I'm not saying that this is true. I'm saying I think they would contend to you that the distinction here is that in the EPA case, we're talking about a federal agency, right, creating policy and redefining, standards, this sort of thing. And that's the federal agency itself. Which, yes, at the direction of the president.
But this had to do with the Department of Homeland Security, which is the same thing.
It does.
It's no different than EPA.
But I think what they would contend is that the difference here is that you had a policy or standard that was instituted by one president, and then the question is you have another president coming in who wants to change that policy that was instituted by another president. Does this president have the right to end that policy? So the court's saying this is not about the federal agency's authority. It's about the executive, is specifically in this case, the president's authority to end a previous president's policy. Can you do that? And basically the court's saying, well, yes, that's been done, for a long time. And yes, you can do that because it's not codified in law anywhere, which would then support their, Congress hasn't said you can't. So therefore you can. I agree with you that I think it's, that's a very fine technical line that they're attempting to walk. But to answer your question, I think that that's the line they're attempting to walk.
I have two big points to make about this case. So the first one is when we try to look at what type of conservative we're talking about. So there's the conservative sense of the dissent where they're saying, do not let these immigrants into the country to wait for their cases to be heard in courts. And then there's the conservative sense of giving the president power to do what they want. And both of those are two separate conservative ideologies that are somewhat conflicting in this case. And this is still somewhat a conservative decision because it's giving the president an executive authority, absolute power to determine this issue. And then the other one is a conservative decision because it is keeping illegal immigrants out of the country. Justice Samuel Alito, in his dissent, talks about the border crisis, how extreme the border crisis is, and how this decision will just let millions of illegal aliens flood into the country using the word alien.
But there's not a climate crisis, right?
Different dissents.
But it's the same people.
Right.
The same people who took the right away in the EPA case are the same ones who want to continue to give the right to keep the people out.
The reason this decision came down the way it did is because you had And on the political spectrum, right, you had 3 justices probably on the liberal side who politically don't want Remain in Mexico to continue, right? That's why they're against this, is not because of what the law says or not because they think the president should be strong, but because they don't like it, right? Just like the dissent is upset because, they don't like getting rid of this. So you have those. And then what you have is the conservatives splitting on what they value more, right? Which is the question of, do we more care about the immigration issue, or do we more care about the power of the executive?
But you just supported my entire premise of arguing on this show, is that the Supreme Court is a body that is worried about politics. It's not basing its decisions on the document. They are a political entity. I mean, you go back to the Dred Scott decision, it was made by slave-owning judges. But they were reading the Constitution, and they read that the Constitution said it was okay to own slaves.
Well, and even if it did,
take them anywhere you want. But that's according to them. That's the way they interpreted the Constitution. But the justices that voted for that were all slave owners. But you're going to tell me that they're going to sit there and say that politics had nothing to do with it. I think it's a misnomer that elementary school teachers maybe. Hopefully high school teachers don't. But, in today's world, we're not allowed to teach any questioning of anything because that's not the role of the schools to think, to create independent thinkers. We have to talk about how the United States government is perfect and never made any mistakes.
I think part of the problem is that even if you could contend that they were not bringing politics into it, it's just the sheer nature of different theories about balancing conflicting issues, because you have cases that expose loopholes in our laws, right? For example, I think the election law case is a good example of that.
And what's wrong with admitting that it's not a perfect system? I have a real hard time that we're going to school boards and we're kicking people out and we're threatening teachers and administrators because you're pointing out that there are flaws in the American system and the American way of doing things. What's wrong with that? If you don't admit there are flaws, if you don't teach the flaws, how do you ever fix them? How do you ever make it better? How do you ever improve upon it? You mean to tell me this is the best we can do? This country that we have right now is the best that we can do? I sure hope not. I hope we're striving to make it better. But the only way you can make something better is if you admit the flaws and the mistakes that something has so that you can go in and fix them.
And we've changed how we do things a number of times, haven't we?
Multiple times.
And we have a good historical precedent.
But now all of a sudden we're saying, oh, we can't teach that. If you're not teaching the wonders of American democracy and you're trying to stray from that, then your job's gone.
Well, because for somewhere in the neighborhood of 50 years, or maybe a little more than 50 years, our Constitution, there were slaves under our Constitution, right? Well, we said, we don't want to do that. We're going to change that. We also noticed that the Constitution was leaving out some guarantees of, things that we decided were essential, like freedom of press and the right to bear arms. So, the point there, right, is that the Constitution, when it was written, and even what we think of the Constitution as today, is wholly based on the fact that we've added to it and changed it and struck down parts of it and modified it over time because we figured out different things. We either decided our priorities were different as a country, or we decided that the Constitution in certain areas was too ambiguous. And one of the points I'll make there that I think we all agree is a good thing is, cleaning up the succession of power, because we realized, oh, hey, this isn't spelled out as clearly as it should be. And that's probably bad. We probably need to be more specific about how and when the vice president assumes the powers of the presidency. Because not being specific about that and not explaining how it happens is a recipe for bad news. And so I think that, we've taken opportunities before to clean things up like that. And if this election law case highlights that, this probably could have been written better, because it isn't terribly clear on what it means, and how broad that is to be, and whether or not you have to listen to state constitutions. So there are opportunities to change it. And to your point, I think that's how we hopefully build a better country, is if people are willing to say, maybe we don't have it figured out yet. Right. And also not relying on the Supreme Court to be the body that fixes things for us. Because that's really, again, not really their job. Their job is more to settle the gray areas, or at least make decisions on the gray areas. And then if we don't like their decisions, we have the ability to not listen to their decisions. We have ways to do the opposite of what they said, if that's what we really want.
I would like to add one more thing. Nomology. Thank you.
You have to use it in order for it to count in some context.
The nomology, I really agree with Lance and the nomology of the Supreme Court decisions, that they are inherently political.
Was that used in proper context, Lance? You count that one?
It was kind of close. It was iffy.
It's up to Bradley anyway. Don't ask me. I don't have any power on this show.
It's just the illusion of power.
It's Bradley, and then Justin, and then me.
Where's Richy then?
He's probably even with me, because I never can get up out of the, that's like why I don't allow pets at my house. I never wanted to be lower than I already was.
The pets come in, you're just going to get downgraded.
Instead of being fourth, I'm fifth, sixth, seventh.
This is going to get lower. And
last is last, but being fourth and last is better than being seventh and last.
So Lance, why do we have this conversation today?
Because I love the Supreme Court. I really do. Contrary to what it sounded like in this, I think it's an interesting body. But basically it's to educate people by providing honest, open, and respectful conversations, because that's a mission we have here at True Chat. And in order for them to keep paying me, I got to stay true to the mission. So we tried to have a positive, honest, open, respectful discussion. And honestly, you heard us that we don't agree all the way through on this. But hopefully you enjoyed the show. You learned something. And that's what it's all about, because we can't make it better if we don't learn. We can't be sticking the muds and stay the way we always are. And tell your friends about us, and tell them as a podcast. They can find us on Spotify, Overcast, Stitcher, Apple Podcast, and everywhere podcasts are found. And the more people listen, the more I get paid.
I'm not sure that we disagreed today. I'm not sure that there was much in the way of disagreement.
I don't know. I was fired up. I wasn't really listening to what everybody else said. I was just mad.
I had things to say. I got upset.
I had to get my point across.
Who won today with nomology, Lance?
I thought it was
in your best judgment.
I thought it was a two-way tie.
Yeah.
And then Richy trying to get in there at the end.
I don't think I heard either of you say it once.
No, Justin used it early.
I did. And
I used it in the second segment. But that was the only time I think it was there.
So, Bradley, you'll make sure that the right person wins, as usual, for the State of Us. I'm Justin T. Weller.
I'm Lance Jackson.
I'm Richy Richardson.
Special thanks to producer Bradley Bush for making the right decisions today and ensuring that the facts come down on the right side of things. Thank you all for tuning in. We'll see you next time. Be the change. Be sure to check out our website, thestateofus.org, for books, articles, and all the ways to tune in. thestateofus.org.